Good afternoon, everyone. Thank you so much for joining our next community conversation. I have muted you and we're asking you to stay muted. It's just easier to keep the session flowing. But you're more than welcome to ask any questions in the chat box, or we'll have like a 5 minutes at the end of the session where you can also ask your question if you don't want to type it. I will be monitoring the chat box, and yeah, we're going to start a session. Johan, thank you so much.
Good afternoon, everybody, and thanks for joining. I'm Johan Kruger. I'm the Vice Chairman of CASA, and welcome to all of you on today's community conversation. I'd like to remind you of two dates. The first one is the 29th of August, where we will be hosting a day conference for office administrators. Be on the lookout for the emails and the social media. And then secondly, the next M100 course will be from 20 to 22 September. It will be classroom style, and it will be at Beaconwood Golf and Country Club. And again, look out for the emails and the social media. It should be out there within the course of next week. And we hope to fill the courses and see you all in class. So today is all about legal wise. We've received quite a number of questions. On the panel today, we've got two members. The one is AJ Van Rensburg and Quintin, and they will also explain to you or do a bit of self-introduction in their practice, but they are our two legal eagles for today. And to AJ and Quintin, welcome. And I really hope that you can play the role of the Constitutional Court today for the next 45 minutes and answer all those difficult legal questions. Welcome, AJ, and welcome, Quintin.
Thank you, Johan.
Thank you, Johan. I spoke to Quintin this morning, Johan, and we took a decision to keep it crisp, just to accommodate more members with the free of charge 3/4 of an hour with the attorney. If there's something we maybe don't get to, whatever, we can always chew it more on the community portal and send it out subsequently. Reluctantly, my colleague has agreed to that.
Okay.
Yes.
And then also to those of you on the Zoom meeting, you're welcome to pop your question into the chat box. And I will monitor the chat box and make sure that we get to your question. AJ, yes.
No, sorry, Johan. With that said, I think most of the participants are sick of hearing my voice. So I'm going to give Quintin the opportunity to discuss a contentious topic first, and then we'll step over to mine.
Okay. So Quintin, shoot away with that contentious topic if you're ready, and then I will facilitate some of the questions that we've received to date.
Okay. Good afternoon, everyone. Thank you for your time and joining us in this discussion, just for us to perhaps get some debate going around certain issues. I'm Quintin from Barnard Attorneys. I also deal with community disputes, community schemes all over the country. My practice is also aimed at dispute resolution with body corporates and homeowners associations. And a topic that currently is pending and is a contentious topic in not only the courts, but also what we find in CSOs is disputes regarding rules. In terms of the homeowners associations creating the rules and the owners wanting to be involved in the tedious process of the rules. For us as attorneys, we have the saying that too many cooks spoil the broth. And that's why you actually elect these parties to be involved, your board of directors to be involved in the active, together with the attorneys, the active decision-making in terms of the rules. So not only that, but if you look at the current case law, the biggest, can I say, disputes arising from rules is actually building penalties. And so in terms of a lot of homeowners association and community schemes wishing to draft their own rules, not with the guidance of perhaps a legal professional, that the wording of said rules is not in line with what they actually wanted, and then that results in the dispute. So I would perhaps like to open the floor for owners, for the members joining the meeting, in terms of what is their views on the owners being involved in the process of drafting, reviewing, and amending rules, and then we can get the conversation going from there.
Yeah. Thank you, Quintin. While we're waiting for those comments to be put in the chat box, one of the questions that I've got to you and AJ, in terms of the let's start off with the Companies Act, and then later go on to the MOI. Who approves the rules? The members or the board of directors?
Johan, I'll take that one because it's an easy one. You can give the more tricky ones to Quintin, please. Please make a note, those estate managers, when you've got a spare moment, look at section 15 of the Companies Act. It's very self-explanatory, to the effect that the Companies Act empowers a board to adopt rules that are not governed by the Companies Act or by the MOI itself. Now, just as an example, barking dogs, the Companies Act is quiet on barking dogs. So then the Act says it's rolled over to the board to make, adopt, repeal rules governing that provision, or to regulate barking dogs. Then section 15 continues along the following lines. Once the board has taken a resolution to adopt a set of rules, it must be filed with the Companies and Intellectual Property Commission. I need to interrupt myself. I often get asked, what about CSOS? At this stage, the Act does not dictate CSOS, although it's not illegal or a transgression of the provisions of the Companies Act to also file it with the CSOS. At the next members meeting, and I want to underline the next members meeting, those rules that were adopted by the board gets delivered to the members via a notice to ratify the rules. Now, Quintin will agree with me that ratification does not open the floor for a fresh deliberation of the rule. Ratification is yes, we accept it, or no, we do not accept it. Johan and participants, the resolution is an ordinary resolution, so it means more than 50%, then it is ratified. That ratification resolution again needs to be then filed with the Companies and Intellectual Property Commission to give it legal enforceability. In the unfortunate event that a rule is not ratified, that non-ratification, if I can call it that, also needs to be filed with the CIPC, and the board may not, within a period of 12 months, accept a similar rule without first getting a special resolution to empower the board to take such a rule. Nowadays, often in courts, the argument commences with, AJ, can I see the state's certification of the rules? Now, what the CIPC produces back once you file those rules is an official certification. The board one we call a 16.1 certification, and the members' ratification is called a 16.2 ratification. And as I say, it's an official document issued by the Companies and Intellectual Property Commission, which certifies that those rules has been filed with the Companies and Intellectual Property Commission. Unlike the sectional title fraternity, the CIPC does not work through the rules. like the Ombud does for the sectional title fraternity. So it's merely a process of filing. Jan, if that answers the question.
Yeah, so AJ, I've got a few follow-up questions because that's what we deal with in our world on a regular basis. So first of all, if I hear you correctly, the Companies Act is silent, not the company, yeah, the Companies Act is silent in terms of filing with CSOS. But am I correct to say that the CSOS Act requires you to file your rules with them?
The sectional title fraternity.
The sectional title. So as an HOA, I don't have to file my rules with CSOS, but it's good practice to file it with CSOS. Am I correct?
Yeah. Yes, you know, it's good practice. It will not make the rules unenforceable purely because you did not file at the CSOS. In my crystal ball, I think it is a question of time when we will also migrate to the CSOS to regulate that custodian position of rules of HOA. But as we speak today, it's the CIPC.
I want to get to the MOI and the filing of the MOI because I think it follows the similar thing. Just to go back onto the rules, because that's where a lot of us fall short and debates at members' meetings and probably more specific at AGMs because this is why we do it. So from a practical point of view, for the non-legal qualified people on the conversation like me, the board decides, and I'm using an example, the board decides to adopt a rule that speeding on the estate from now on, or the speed limit is 40 kilometers an hour. I'm using a practical example. The board accepts it, they approve it, they say, yes, from now on in the estate, the speed limit is 40 kilometers an hour. Then they start to enforce it. 6 months later, they come to the AGM. Now the rules need to be ratified. In this case, the members say, no, we do not ratify it because we disagree with the 40 kilometers because it used to be 30. And I'm, again, practical. What now? Do they have to write back the fines? You mentioned that for 6 months, they cannot bring that rule back. Am I correct? And also there was something that you mentioned in terms of the approval at the members meeting was an ordinary resolution of 50 plus carry. But if I bring it back, is it a special resolution, which is then 75% of people present at the members meeting? Just clarify that because that's the question that we as estate managers get asked and deal with often. And before I give you a chance, I sit in a board meeting, there says 6 directors, each one think it's different and say, no, my mate who's an attorney says it's this way and that way. Can you clarify that for us? Because then we can move on to other stuff. And I think we've covered rules then in terms of approval and enforcement and what does ratification mean and those kind of things. Thank you.
Okay, thanks, Johan. Johan, the period is 12 months. Upon a non-ratification, the time bound for the board is 12 months, which they cannot accept the same rule. In section 15, we also got another provision, which is very interesting, if I can call it that. It states that if
AJ, can I stop you there? Sorry. This what you tell us, that comes from the Companies Act. Am I correct? Okay, yes. Sorry. Sorry, my apologies.
Yeah. And again, members, it's easy reading. You don't need to be legally trained. Page through it when you've got a spare moment, section 1.5. Section 1.5 also has a provision that even if there's a non-ratification of the rule, the time period in terms of which the the board's rule were legally enforceable, and that's the period up to the ratification, stays legally enforceable. So what it states is that those members that transgressed the 40-kilometer-hour rule up to the time it was not ratified, they remain liable for the penalty, Johan.
Okay. Thank you for that, because it creates grey, and then only 12 months later, and it's in the Companies Act, so it's fairly simple.
Yeah.
Okay.
Yeah.
All right.
Johan, May I, just for setting the scene, the interaction between board members and members of the community of the association, just repeat myself so many times. The MOI is a contractual arrangement. It's something that you enter into voluntary when you take transfer of the stand. Read it before you enter into the relationship, because it has a provision where you empower the board to take legal and binding decisions, such as rules. And part of the arrangement that they can take legal and binding decision incorporates that they can regulate certain of the affairs of the association, your conduct, and they are empowered to do so. And then in the MOI, look at what can they regulate. So we've got a question, who can regulate the board, and then what they can regulate. And spend some time to read the MOI, and you'll get a clearer understanding of who regulates and what can they regulate, such as your conduct on the way that you maneuver your vehicle.
And that conduct rules, the same applies to architectural rules in terms of the process. So if our architectural rule states that we only allow white houses on the estate, and we want to change the paint color to blue, the board can make that rule, depending now obviously on the MOI, goes to the members for ratification, and that same process, either barking dogs, speeding, or architectural rules, the process to be compliant with CIPC, the same process.
Yeah. Johan, I want to steer clear from conduct rules, management rules, architectural rules, because mostly in architectural rules, there are more called guidelines. So there is a kaleidoscope of, coming back to your example, there won't be phases or shades of white, but that will be then an architectural rule. But if the kaleidoscope allows certain building styles, then at least there are guidelines, architectural guidelines.
Okay, thank you, AJ. I just want to pick up with Quintin in terms of the rules. You asked the question earlier on, should members be involved in making rules? Was that your question?
Yeah, so it was my questions that I wanted to pose to the estate managers in terms of their feeling from, I can understand being involved in some quite heated debates with members at meetings where they feel that they are entitled, due to the payment of levies, to be involved in the day-to-day running of a scheme. And I think it is to add to AJ's argument that owners need to be aware that directors and can I say companies, in this instance the homeowners associations, the directors are very much regulated, are very much, yes. So
it depends on which hat I'm wearing.
Yes,
in the community where I'm staying, I want to be involved. And at the estate that I'm managing, I don't want the members to be involved. I want them to stand on the sideline, and allow me to manage the place. Okay.
Yeah, so I'm a firm believer from a legal perspective that if you take it into another company as well, if you are a shareholder at Coca-Cola, go try and knock on their doors and tell that board of directors to do what you want. They have been chosen by the shareholders to act as the board of directors. And when you look at section 13, section 67, and again with the regulations of the Companies Act, directors are very much regulated in terms of the actions that they may do, and the consequences of not following those actions are quite severe. And the courts, in a lot of the judgments that we received last year in 2022, the courts, when they're interpreting the memorandum of incorporation, they look a lot to the nature and the objects of the company. That's the first start. That's the starting point, which they determine if any board has made any decision outside their scope of powers and not in the best interest of the duties. So I think that there's a common mistrust between board members and the board of directors, and that gives them the little bit of, because it's not really a company, it gives them the right to say, listen, but you need to listen to me. I pay you. So, and like I say, just to get back on, I think that too many. If you have a big board, imagine you have a big board of 7 people. 7 people or 7 to 10 board members can't even decide on what rules to incorporate or provisions to have in an MOI, and which can take months with an attorney just to get a concept to propose to the owners. Imagine you have a big estate, for example, one big here down the road here from where I am, where there's 400 units. Imagine getting 400 owners to decide which rules should be incorporated in your rules and or provisions in the MOI. It will defeat the purpose of the association actually achieving their goals. So that's just my 2 cents on.
Your example of the board, it's quite small. I'm managing a estate, 115 owners, 11 board members. So you imagine how we make decisions there.
Yeah, and it does for achieving those goals. Instead of a normal process of reviewing and updating an MOI and rules with my offices can quite be done efficiently and effectively within, I would say, realistically 4 to 6 weeks. But with these type of boards, it can take up to 6-7 months, because everyone has their own subjective opinion of what should be included in there, and they have their own agendas there. And not listening really to their duties towards the HOA, and that's create issues. So imagine you say 11 directors. Imagine you have 115 owners wanting a piece. What we've done in the past, where owners do want to be involved in this process, we do, and I think AJ can attest to this as well, is that you give them the satisfaction or the authority to do a subcommittee. And they can then be a representative the same way that a shop steward would be for a company, and they come to the board, say, listen, this is the concerns of owners and members that they want to have incorporated in some manner if it has any legal reference. Yes, if it has any legal standing, yeah.
Your example of the committees that nowadays been replaced by WhatsApp groups. So AJ, Quintin, we all know that we govern by a Companies Act. Okay, so there's a Companies Act. Just guide us where in the Companies Act, under which section or article or wherever would you find the section on NPCs? That's my first question. My second question that we received is, I arrive at the estate and I get a MOI. It say this is the MOI. What sort of governs the MOI, and what should be in the MOI, and where does the MOI originate from? And what should be in the MOI, and what's good practice that is included or excluded? If both of you can maybe have a go at it, please.
Quintin, I'm older than you and more beautiful. So yeah, Johan, to assist the estate managers in your first question, please look at Section 10 of the Companies Act. It states specifically which of the provisions of the Companies Act are not applicable to non-profit companies, normal HOAs as we know it. So just have a read through that, and it will give you a broad view of what sections are not applicable. And then secondly, go with a fine-tooth comb through Schedule 1 to the Companies Act, which deals specifically with non-profit companies. And then thirdly, they asked me, what are alterable and what are unalterable provisions of the Companies Act? And the rule of thumb is, if the provision in the Companies Act starts with unless otherwise stated in the MOI, then this is the following provision. If you don't find that entry line, Johan, then there's a good chance that you will maybe working with an unalterable provision of the Companies Act. It cannot be, the MOI provisions cannot be contrary to that provision. Now, where does the MOI come from? During the development phase, the developer normally has its set of attorneys, which they then ask to draft a memorandum of incorporation, which gets lodged simultaneously with the registration of that company. And it's not uncommon that that MOI carves a favorable dispensation for the developer in the form of not paying levies and in the form of having the powers to appoint members to the board, not elect, simply appoint and chop and change as they go along. Then we get to the end of the development period, post-development period, and then it's the golden opportunity to revisit the MOI and to then, I would not say write up the developer, but then to incorporate provisions in the MOI to cater for the post-development next 10 to 15 years to provide the community who has now been established some good service. Elements of an MOI, in our world, we call it the essentialia of such an agreement and the naturalia. Now, the essentialia is, if I can use an example, such as a rental agreement. It must set out the landlord, it must set out the tenant, it must set out the premises that will be rented, the monthly rental, etc. And for the purposes of the MOI, it must set out whether it's got voting members or non-voting members, or both of them. It's not uncommon for an MPC to have both voting and non-voting members. And then it must set out the basis upon which you become a member of the association. And then it must empower the board to what they can regulate. And elegant also is to what decisions are ring-fenced for the members only to resolve upon to the exclusion of the board of directors. And John, those are more the naturalia which you tweak and panel beat and chisel until the community is satisfied with that provision. And after Quintin has spoken, I'll go back to an example of an MOI where we provided for building levies, but not building penalties, and how the court dealt with that wordplay that we had in the MOI. But Quintin, first off to you.
Okay. So Johan, if I can go back in terms of, I'll just address, I think what AJ said regarding the provisions that are in the Companies Act that deal with an MOI. If you look at the Companies Act, it's 168 pages. So to make yourself acquainted with each and every section is quite impossible. And that's why our industry has changed over the years, and we've adopted industry-tested memorandum of incorporations. We've developed these MOIs to suit our industry. So when something in terms of the law develops, we add it or we remove it. But in terms of the contract that it constitutes between a member and an owner, I think if you look at anything that you find in the relative, the Companies Act is there as a secondary supplement to a MOI due to the fact that it being an MPC. So if something is not in the MOI, you can always advise the Companies Act. And this is the most suitable solution due to the fact that the Companies Act is one of the most difficult acts I've read, and sometimes the interpretation thereof can be quite extensive, and therefore the reason why MOIs are created to such an extent that the wording of same is that everyone can read and everyone can interpret, and you want to include as much information as the MRI in the MRI to effectively to give the board and the members know that they know exactly what is expected of each other. So I would say that's how you determine what should and what should not be included in the Companies Act. And then when we look at the provisions of an MRI and where it comes from, AJ has spoken about the developer and being involved with from development stage myself with certain complexes. I can obviously confirm that in those instances the developer does create provisions to favor him a lot to ensure that the development that he had in mind does come to realization without the interference of perhaps parties that does not share the same views as him. Due to the fact, I think that you, Johan, being a estate manager in terms of some of these complexes where some of these estates where the developer is involved, even after already 50 or 70 people has moved in, but he still hasn't completed the estate that he envisioned. So he needs to have those provisions to protect him until the development phase is over with. And then it becomes each MRI needs to be tailor-made. I don't believe in blanket solutions. Blanket solutions is cause for trouble. You need to understand the dynamics, the social, economic circumstances of each estate in order to adopt a appropriate MRI. And obviously, the adoption of an MRI is regulated in terms of Section 16. Just to interrupt myself as well, if you perhaps look at some of these MRIs, if I could take one example, Section 65, I think it's Section 65, dealing with electronic meetings. A lot of MRIs does not have the provision in them that they are allowed. However, the Act does make provision for them. And the default position is if the document doesn't have it and the Act makes provision for it, that's the default position. If there's a specific provision that prohibits it, then that's what AJ refers to, unless the MRI states otherwise. So these two documents need to be read in conjunction, and it's important that you, like AJ said, read through the document, that you understand what you've contractually agreed to. But in essence, you don't need to be an attorney, but it would be advisable for estates to have an attorney. You have an auditor to deal with your tax, finance, and tax stuff, and your accounts to be able to guide the estates on the interpretation of this and what they can and cannot do, what you can do and what you should do.
Thank you, Quintin. I've got a question to you and AJ. We've used the word before, sub-C. Who are they? What do they do? Where do we find them? Can I do it myself? Do I need to work through an attorney, or help me?
Johan, SIPC stands for the Companies and Intellectual Property Commission. It's what we used to know in the old days as the Companies Office. So it is established in terms of Section 126 of the Companies Act, and it's an official office. And secondly, you don't need an attorney to liaise with SIPC. They are user-friendly. The auditors or the accounting firm of an association can provide a similar situation or a similar service with CIPC to change the appointment of board members, to file rules, to file memorandum of incorporation. But as I've stated earlier, Johan, nowadays the latest offences produce your certificate. And if you can't produce that certificate, you may have a judge which says, well, seems like you're not going to get out the starting blocks because your rules for MOI may be unenforceable due to the lack of the filing of those items with the Companies and Intellectual Property Commission.
So that's the CIPC or SIPC or the Companies Intellectual Properties Commission. That's where I update my directors and company secretary. That's where I file the rules, and that's also where the MOI is filed. So if somebody is looking for the latest approved rules or MOI, that's where they go to, not the one that the estate manager has got in the file in the office. It's the one that's with the CIPC. Am I correct?
That's correct. Johan, just briefly, you mentioned a company secretary. Please be aware that only a public company needs to have a company secretary. Section 83 of the Companies Act states that for purposes of an MPC, if the MOI dictates the appointment of a company secretary, only then does an MPC needs to appoint a company secretary. So they asked me, why do we file at CIPC? Simple. It's a public office. It is a public office. So if I wish to acquire property at ABC Estate and I want to ascertain what's the legally enforceable MOI, what's the legally enforceable rules, me as Joseph, member of the public, can liaise with CIPC and ask them to produce those source documents, and I can familiarize myself which ones are the legally enforceable ones.
Thank you, AJ and Quintin. We've got another 6 odd minutes left before it's 2:45, and we said 45 minutes. I've received another question from of the members in terms of the annual general meeting. Is it required? That's the one question. Secondly, is when must it take place? Is there a limitation in terms of the Companies Act or the MOI? And what is typically topics for an AGM? Is there a prescription or a different, or is there some guidance to say these are the items that should be dealt with at the AGM? In short, what's the purpose of the AGM and when should it take place?
Johan, the practical answer is the AGM is the opportunity to give the estate manager all his help.
Sure. and remind him that we are paying his salary.
Indeed, sir. Yeah, no, that's on the lighter side. The Companies Act only dictates for a public company to convene an AGM. The Companies Act states that any other company must hold an AGM if its MOI so states. So if you are in a fortunate position that your MOI is silent on an annual general meeting, especially in instances where you've got no voting members, why do you want to call an AGM? So just to be clear, it's only a public company that's dictated by the Companies Act to hold an AGM. But the Company Act then states that if you are obliged, in terms of your AGM, sorry, in terms of your MOI to hold an AGM, then it's got a list of items that needs to deal with. Sorry, Johan, I can't put my finger on it, but it is the annual financial statements, the director's report, which often is part of the annual financial statements, the election of board members, and more or less that's it. I'm still to find where minutes of the previous AGM needs to be approved. It has, I believe, evolved via King and good governance, etc. But if they ask me shortly after the AGM, sign them off, send them out off the table. Let's move on. Let's go to the next one. Because it's just so bizarre that a year after Mr. Joe Soap raises his hand and then he wants to challenge those minutes, and most of the people can hardly remember what happened at the previous AGM. If that will answer the question, Jan.
It does. What I don't hear and what I like is I hear that the very strong legal advice that we receive from our panel today is please exclude general from the AGM notice. Thank you for that free advice, AJ and Quintin. The people on the members on the Zoom conversation is going to send emails now to their board and say, general is off the agenda for the next annual general meeting. I wish.
The owners can call it, they can call a special general meeting if they want to discuss general stuff.
Yeah, I think we've learned over the years, and maybe Quintin and AJ, just as a comment, in terms of the approval of MOIs or changes to the MOI and those kind of things, is to maybe don't do it at the AGM, but at a members meeting, special meeting, general meeting, straight after the AGM as a separate meeting and a separate agenda item. That's just as a side comment.
Yes, Johanna, it can avoid that your AGM, which needs to do with statutory stuff, being hijacked by contentious issues which they want to deliberate. Johanna, I know we've got 2 minutes, but I just want to briefly touch on a building levy versus a building penalty.
Thank you.
Shortly after the commencement of the current existing Legally Enforceable Companies Act, it was May 2011, we rolled out probably the first MOI for an MPC in South Africa. And what we did was we made provision in the MOI that if you own an empty stand, you will pay an additional building levy, purely because it is an empty stand. Like, for instance, some people have bigger stands, some have smaller stands, and to find a proportionate contribution dispensation, bigger stands may pay more compared to lesser stands. But those were the provisions of the MOI, and the one member with an empty stand did not pay the building levy, so it followed its route to the court to rule upon. And the defense was, it doesn't matter how you look at it, court, it stays a penalty. I get penalized because I have an empty stand. Now, penalties are also regulated in terms of the South African law, in terms of the Conventional Penalties Act. Now, in very layman terms, what the Conventional Penalties Act states is that if you are dissatisfied with a penalty being imposed upon you, you may approach the court, and the court can then intervene on the contractual relationship and bring the penalty down or tone it down. Now, there's one reported matter on this, and it's in Erenville, where the court brought 10 times our monthly levy as a penalty down to 7 times. So, and most of the building penalties are normally twice a monthly levy, up to sometimes 4 times a monthly levy. So we're still far from 7 times a monthly levy as a penalty that the court will intercept and rule upon. Long story short, in this matter, the court did indeed rule up against the state that although it states building levy, it is in essence a penalty. But because the defendant provided the provisions of the Conventional Penalties Act, the burden of proof on him was to persuade the court that the penalty does not equate to the damages sustained by the MPC, which the member could not satisfy the court of. So despite finding it a penalty, it still persisted in the full collection because the defendant was unable to bring it down via the court's intervention. But I still believe that if the MOI is properly worded to the effect that you will pay an additional levy than your monthly levy, purely because it's an empty stand, the court will uphold it and say, it's not a penalty, it's an additional levy you pay. And the basis therefore is, time will come that you'll need to use the internal roads, bring your trucks onto site, thrash the internal reticulation, the internal roads, etc., upset the whole scenario with the dust, etc., and we compensate this for an additional building levy until such time as you break ground and we've got a fully built up estate.
AJ, Quintin. Yes.
Sorry, Johan, can I just add one more thing there on that? So if just to add on AJ's thing there, what I've experienced from my side just with building penalties in that instance is that I urge state administrators to have a look carefully at your wording when it deals with building penalties, especially the issues where the disputes are mostly boxed in, if I can use that term, is actually disputes is when an owner has taken transfer from the developer and then subsequently has transferred again. That interruption normally causes people to think, no, but I'm still within the 3-year period or 2-year period. So I think, with respect to my fellow colleagues in the industry, is that a lot of people, when they do the initial MRIs, don't look at this wording. They just copy and paste it without having regard to the judgments that we have, where these issues are 3 or 4 or 5, 6 times a year, are in appeal court or are in the high court. So that's one thing I would, the estate managers, to go have a look at, to see if these provisions actually do align with what the courts are saying we need clarity on.
Thank you, Quintin.
Okay.
Thank you very much. I mean, we've come to the end of a very fruitful discussion around legal matters specifically for HOAs. For those members who joined us, thank you very much. Please follow us on the social media. I did post the necessary links in the chat box. That's where we communicate most. And on Mail Blaze, you've seen we've changed it from Outlook to Mail Blaze over the last month or two. Just a reminder that the next course will be for office administrators. It will be a full-day course at Peakenwood Golf and Country Club on the 29th of August. Be on the lookout for that. And the next M100 course will be from 20 to 22nd September, also at Peakenwood Golf and Country Club, classroom style. Be on the lookout for that. And to our panel, to AJ and to Quintin, thank you very much. And to the background, Anay, you can wave at everybody, give us a wave, who handles our social media and assist us to host the community conversation. Thank you very much, everybody, and enjoy what's left of the week. And for those of you from Gauteng, I believe the cold weather is on its way. Thank you.
Thank you.